So start with closing. I talked about this last, so I'm not going to spend a lot of time on it in this lecture. But one of the ways that you figure out how do you get off that blank piece of paper and how do you construct this cross is you start with closing. This is a witness that is appearing. The other side has called this witness. You are the opposing counsel, right? So it doesn't matter whether you're plaintiff or defense, prosecution or defense. It doesn't matter what side you're on. If you're on cross-examination, the other side has called this witness. What is it that you may say about this witness in closing? What is it that you may say about their testimony? So I started this. Will you discuss this witness in their testimony or not? As a prosecutor, once in a while, we get a witness that comes up. It's a character witness. It's mom of the defendant, right? Am I going to comment on mom? Am I going to comment on this character witness? Maybe sometimes, most likely not. And if I don't have anything that I plan to say in closing, that dictates what I do on cross. I don't have a question on cross. And understand what this communicates in my courtroom, right? Mr. Porter, do you have any cross-examination for this witness? Your Honor, we don't. The witness is excused. Thank you very much. So I've communicated something in my courtroom, not only to the judge, not only to opposing side, but most importantly, my audience, the jury. Apparently, this witness doesn't even hit home enough. This witness doesn't even cause enough problems for him to ask one question. That's what that communicates. So start there. Will you talk about them? Will you talk about this witness, who they are, or will you talk about their testimony in your closing? If the answer is no, no questions. I used to have a co-counsel. I didn't quite agree with the way she did it, but I used to have a co-counsel, and it would basically say, there's no need to ask this person questions. She was from New York, so she handled it a different way. No need to ask this person questions. It was more my cousin Vinny's, right? It was like, I got no need for this guy, right? And you move them along. So if you're looking at the witness and looking at their testimony, and remember, you can evaluate some of this at the front end. You can say, I know what this witness testifies about. I know they're a character witness, or I know they just picked up an item at the scene, and decide whether you have anything to say. But also, you're going to learn it through their direct examination. That same witness that I told you that I didn't know was going up to the stand or didn't know who they were, that same witness where I did rock, paper, scissors underneath the table to see who should handle the cross, I better be listening then, because I don't have anything to go on. And if I listen to direct, I'm writing things down, and I'm writing down what could possibly be what I would say in closing. And I'm writing down then how I would organize it into cross blocks. So start with, are you going to say anything? Go to, if it's yes, what do you want to say about his or her testimony, right? We're talking about facts, and we're talking about evidence. So testimony is evidence, and so is the actual pieces of evidence that you may put in, whether it's documentary or real evidence or whatever. That's what to go on. That's what you're going on for closing. That's what they're going to decide the case on. So look at the testimony first. If I look at this testimony, is it going to be something that conflicts with my theory and the way I look at the case? Am I going to say something about this testimony? Do I need to address this testimony? The character witness, obviously I made a determination that no, I don't need to address it. I don't actually need to confront this testimony whatsoever, right? He can have shoplifted from the store and taken items out of the store and be a really good son. Doesn't really impact me whatsoever, right? It's just the fact that mom had good things to say is not something I have to address, so I don't have anything to say about the testimony. What do I want to say about this witness, right? If they have huge categories of testimony that fly right in the face of my theory. Mine says that this was a car accident and it was caused by him and he rear-ended my vehicle. And yet the other side says, no, actually this is someone that stopped short and it's their fault. It's like a he said, she said, car accident. Both versions, and they fly completely at odds with one another. Then the way we should be thinking about it is, what do I want to say about this person? Maybe I need to go to the person, not the testimony. Maybe I need to, the next step, what can I say about his or her credibility? Maybe they're not reliable on this account. Maybe they've said inconsistent things in the past. Maybe they have a reason for testifying the way they're testifying today. Bias, right? There's all sorts of things that can go into, maybe I'll comment on their credibility. And all juries in all jurisdictions get an instruction about witness credibility. And it says something to the effect of, you jurors, by the way, you're in charge of that. I'm the judge of the law, because I get to wear this black robe, but you, jury, as being the jurors in this case, you're the judge of credibility. You are to judge who you believe. And you are to judge who you believe in whole or in part. So that's a fancy way of saying, you get to decide who you're going to go with in this case. You're the one that gets to say whether they're telling the truth or they're lying. And you don't have to label them a liar. Maybe there's a reason in this case that they got a detail off. Maybe there's a reason in this case that they can't separate their emotions from the truth, right? But you're looking at it and you're saying, what can I say about these people, and what can I say about them as witnesses, and what can I say about their credibility? These are the options available to you, and this is what you're looking at. All right, organizing. So now I've gone through that drill and I brainstormed, either alone or with my partner or someone else in the office. I brainstormed as how am I going to construct this thing based on what I want to say. I actually formulate those paragraphs that are going to be part of my closing. Right? I don't know where it fits. I don't know when I'm going to talk about Mr. Peterson, but Mr. Peterson I know is coming in to testify for the other side. I know I have a cross-examination of Mr. Peterson that I'm looking forward to at trial. I start with that. You remember when you heard from Mr. Peterson at this trial, right? He was the one that said this and did this. He was the one that had these credibility problems. So I start with that paragraph that I want to offer. And that paragraph's going to change, just like all parts of my closing are going to change throughout trial. But I start with that to know what my blocks are going to be. And when I say organize in blocks, I want you to think about it. Here's what you need to kind of think about are the choices that you would come up with. Okay? A big one that comes up all the time, and Professor Rupper is going to talk about this one, or I did talk about this one rather. This is adds nothing, no questions, right? If the person adds nothing, if their testimony adds nothing, and if there's no reason to comment on their credibility, you say no questions. Okay? Think about it. If I'm not going to say anything in closing about mom who comes on as a character witness, imagine if I stand up there, right, and all of a sudden start beating her up about sometimes she lied. Or I start beating her up about her bias. I mean, you'd say anything to protect your son, wouldn't you? Right? Now I'm just losing face with the jury and I'm beating up mom for no reason that's ever going to pay dividends for me. Right? And imagine, right, it makes even less sense if I say, now mom didn't come here and add anything today. Mom didn't actually give you anything about the facts in this case. But let's talk about why she's a liar nonetheless, right? It doesn't resonate with your jury and you're losing points. You're losing credibility with your jury. You gain more credibility by saying no questions. You gain more credibility by never going back to that topic if it doesn't stay on your mission or it doesn't fly in the face of your theory, your case, and your story. Okay, so remember, adds nothing, no questions. I think you'll find, for those of you in trial advocacy or doing mock trial problems, we make sure there's something for every witness. Every witness has dirt, and every witness has lied, every witness does something. But in life, big difference. Look at that witness, see what they add. If they add nothing, no questions. The second one, and this is the one, I'm trying to highlight for you areas of typical pitfalls for law students, first time in trial advocacy or in mock trial, and looking at these things. Look at this witness and think about what facts they have that are favorable to you in your theory. Look at this witness, no matter who they are, and say, what do they have that actually contributes to my theory? Because think about it, it's one thing if you invite someone to the show with an invitation that we call a subpoena. It's one thing that you invite someone and you bring them in and then they have a bunch of stuff for you. Yeah, you brought them. Of course, you knew they were going to have good stuff for you. But imagine how it adds import to your argument and weight to your argument if the other side brought them. They weren't part of your show at all. You didn't even plan to have them here. But they came anyway, and even that person, who the other side called, admitted this, said this, claimed this. Right? It makes it more powerful, because I didn't bring that person, but nevertheless, they still saw him in the store that day. If I got a shoplifting case, and it happened in the store, this witness, no matter what they came here to say for their side, if I can step back for a second and say, so if I get this straight, on January 13th, you did see the defendant, and you saw him in the store, and you saw him in the store at 1:30. Next thing you know, I've just built up favorable facts from my side. Even the person they brought in puts him in the store. Even the person they brought in has him in the store the day that the event occurred. Everyone see that? So look at favorable facts. I think what happens when you go out and you see the less persuasive, you see the non-GGU trained attorneys out there in the world, right? You see them out there in court and on cross-examination, sometimes you're going to have this thought, right? Go watch Real Court or at your externship, you have the time to stray away and go into court and sit there. I don't know whether this person's on direct examination or cross. You know why? Because they're asking the same questions, or they're asking them all open-ended, right? They're not doing what we train and what we talk about. But the most important thing is, if they've already gone through all the facts, and they've already gone through their favorable facts, why they brought them into the room, you don't need to use your cross-examination time when you're supposed to be making these connections with the jury about your side and your case and your story. Don't waste time just going over facts that you've already established are bad for you, right? This is the equivalent of they brought that witness in. That witness is an alibi witness. That witness is saying that my guy, my defendant, was somewhere else that day and couldn't possibly have been shoplifted. Why would I possibly start out and cover in my cross-examination? So if I understand this right, you were playing poker with him. You were 30 miles away. You were nowhere near the store whatsoever. That sounds like I'm reinforcing really bad facts for me. And it sounds like I'm asking them again, albeit leading questions, I'm asking questions that are not favorable to me. So you have to grab hold of the fact of what favors your case and grab hold of the fact of what was bad for you. No need to go over it again. Pick apart, edit, and think about questions. This is why we pay you as, this is why we pay you as lawyers. This is why your profession that you're joining, lawyers, we're not going to be replaced by machines. You get paid to think about these things and organize these questions. All right? Organize the ones that are favorable to your side. Stay away from the ones and don't reiterate the ones in leading questions that are not favorable to you. Another one that's a very popular one, and it's another way of saying favorable facts, but there's plenty of people. Trial testimony is based on personal knowledge. Trial testimony is based on witnesses that has something to contribute. Something that they saw, something that they know, something that they perceived, right? Leave expert witnesses aside, but most witnesses come in because they have something to add and they have knowledge of something, right? But they don't have knowledge of the entire case, or they don't have knowledge of everything. So think about the blocks that can be constructed just to say that this witness wasn't there at that time and didn't see something, or as that witness sits here today, they don't know something, all right? That's a block and it may be favorable to you. The investigating officer shows up at the scene at this shoplift, shows up a half an hour later after the bell rings or after the store owner calls, right? One of the questions that most defense attorneys are going to cover is, so Mr. Investigator, you got there at 1:30. This shoplifting event was alleged to have happened at 1 o'clock. You weren't there at 1 o'clock. You didn't see the defendant in the store. You don't know what happened, right? You see what I'm getting at? We're actually drafting a block that says what someone doesn't know and what someone doesn't see. Because that way, even if the investigator is the most credible witness, even if the jury loved this investigator, and even if they embrace the testimony, right, you have something to say in closing. Yeah, they want to rely on the investigator, and they want to rely on this investigation, and they want to talk about all the details that come from this investigator. Keep in mind, investigator wasn't there. Keep in mind, this thing happened a half an hour before the investigator shows up. Keep in mind, as he sat here today, he still doesn't know who was actually in the store that day, other than that he claims it was the defendant based on things he heard. Right? I have in mind my paragraph in closing already. And if I do cross-examination right, I'll be reminding them in closing exactly what my point is as it relates to that block.